Welcome to Practical, Clear Guidance on Business Law, Probate, and Estate Planning with Meents Law.
Hi, everyone. Welcome back to Practical, Clear Guidance on Business Law, Probate, and Estate Planning with Meents Law. Frank Meents works with individuals, families, and small business owners across Northern Illinois on estate planning, probate, and practical legal guidance. I'm Sean O'Connor, and today we're going to walk through how the probate process actually works in Illinois and what changes when someone passes away without a will. Frank, how are you?
I'm doing well. How are you, Sean?
I'm doing all right. I'm glad to be here. Let's dive in. Right, we're talking about Illinois. What is probate meant to accomplish, and why does it exist in the first place?
Well, probate's meant to orderly transfer the assets of a person who passes away. So this may be a house, a vehicle, bank accounts, etc. Everything that we have in our lives that is probatable, and that's an important distinction. The probatable assets; those are assets that are only in our names, that are not jointly titled, that are not designated to go to someone else through a designated beneficiary, as an example. And that's the purpose of probate and the intent behind probate originally.
What factors determine, whether an estate needs to go through probate at all versus being handled outside the court process?
Well, it's two things. It's the type of assets and it's the value of the assets. So the type of assets, if you have real estate in your estate, and again, this is only in the event that real estate is in your name alone at the time of your passing, then your estate needs to go through the probate process in order to convey that real estate out of your name. The other aspect is the value of the remaining assets. If your non-real estate assets equal more than $150,000 of value, then your estate would have to go through the probate process. Otherwise, under that $150,000 mark and no real estate in your estate, then you can use what's called the small estate affidavit to administer your estate.
How does one end up determining, right? Or is it clear cut? Like, oh, it's under 150 grand, like you said. There must be some sort of means test or?
Well, it's not as easy as we would think. It really depends on how well the administrator or the executor knows the financial situation of the person who passed. Obviously, after we pass, we're not available to say, oh yeah, I have this insurance policy, or I have this bank account, or this certificate of deposit. So that's part of the job of the executor or administrator of the estate, is to collect and gather those assets so that determination can be made as to the value. Oftentimes, the executor or administrator is close enough with the decedent that they have an idea, but that idea isn't always as clear as we would like.
Got it. Yeah, that makes sense. So let's see, once an estate does need to go through probate, that's determined. Can you walk us through how the process typically unfolds in Illinois?
Sure. There's a petition filed with the court in the county in which the individual resided who passed away. And that petition seeks letters of office. Those letters of office give the executor or the administrator the legal authority to act on behalf of the decedent, the person who passed. And this is for the purpose of selling a house or selling a vehicle or moving a bank account into the estate account. So then after that point, after they receive that legal authority to act on behalf of the estate, the administrator or executor gathers the assets, pays any debts or taxes that are due on behalf of the decedent, and then ultimately distributes the assets based on the will, if there is one, or the intestate succession if there is not a will. And then after that point, closes the estate, makes a final report, lets all of the heirs and legatees know that we're closing the estate, and close the estate.
Got it. You mentioned at the beginning of that a petition is filed. Who files the petition?
That would be the proposed administrator or the proposed executor with the help of an attorney.
Got it. That's what I thought. Okay. So I hear, people often worry about how long probate takes. What tends to have the biggest impact on that timeline? Like what's typical, and what can throw that into disarray?
Sure. Typically, when we go in on a petition for letters of office, we will get a 1-year status date. And the reason that we get a 1-year status date is it's the court's expectation that it's going to take about that long to administer the estate. Now, sometimes it's shorter than that, sometimes it's longer than that, but oftentimes that's about the right amount of time. The largest factor in a normal estate, a normal uncontested estate, time-wise, is there's a 6 months creditor claims period. This gives unknown creditors an opportunity to make a claim against the estate to ensure that all of the estate's debts are paid or satisfied to the extent possible by the assets in the estate. The other things that cause further delays are will contests or estate contests, any type of family dispute or dispute amongst those receiving distributions or those set to receive distributions would cause a delay, a further delay, and then an increase, unfortunately, in expenses to the estate.
Yeah, that makes sense. You mentioned kind of a grace period, a window for creditors.
Yes.
How does that actually work in practice? Like, what would be a legitimate claim? Like, is the executor receiving the credit card? I mean, you know what I'm asking. It's like, how does that actually get implemented in practice?
So the known creditors are fairly straightforward. Though the known creditors are notified at the beginning of the process at the petition time, and however, unknown creditors will be notified via publication. So we still have to publish in a newspaper for 3 consecutive weeks that this person has passed, and here's who to contact. Here's the attorney's office to contact to file a claim, and then here's the court, the circuit clerk that the case is being held in, so that creditor can file a claim with proper claim with the court.
I see.
Now that might include credit cards. I think you mentioned in your question, but credit cards. It could be medical bills. It could be other less familiar debts that an individual may have, and that's where the executor comes into play, is to administering that portion of the estate and making sure those bills are paid.
We're talking about wills, at least tangentially here. Where does having a will make the probate process smoother, and where does it not really change things?
Well, there's a common misconception that a will, if I have a will, it keeps me out of probate, and right. It does not. It just guides you through the probate process. So the will gives you the opportunity to determine who's going to manage your affairs after you're gone, who's going to make sure that your assets are distributed to the people you want them to be distributed to. And then it allows you to formulate that list of people or charities or entities that you want your assets to be distributed to after you pass. So that's the power of the will. And if you don't have a will, then the state of Illinois has written a will for you. It's called that intestate succession. And it makes a determination that if based on your status at the time that you pass, whether you were married or unmarried at the time, whether you have living children or no living children at the time, where your estate would go and in what percentages it would go.
So there's no will. The state of Illinois is going to handle that. How do they, or what determines who they put in charge? And and then of course assets are distributed. I'm sure there's some schedule, children, next of kin, spouses, that sort of thing.
Sure. So if you pass without a will, as an example, the distribution of your assets would be 50% to your spouse and 50% to your children equally. So that sometimes sounds okay. However, sometimes not. In those circumstances where there's a home in an individual's name and the spouse is living in that home. However, the children become a half owner of that home upon the deceased spouse's death. So that certainly could cause problems. And then there's no real. The state of Illinois is not out here looking for administrators for estates. When in order to open the estate, someone has to step forward and volunteer or nominate someone else to be an executor or the administrator of the estate, and then to be approved by a judge in court. And that's where the courtroom and the court system comes into play with the help of the attorney.
You mentioned the 50-50 split there between surviving spouse and children. Is that typical or specific to Illinois? Is that a standard thing regardless of where you're living?
Nope, that's specific to Illinois. That's based on our intestate succession laws in the Probate Act. I'm not certain of other states the way that they handle intestate succession. I would imagine there are some states that have very similar intestate succession, and then there are some states that vary broadly, just based on my experience with other probate matters.
Got it. You mentioned the state's not out there looking for executors. I'm curious what does it actually mean to serve as an executor or administrator? And then, because maybe it sounds good. How hard could it be? Sounds, whatever your feelings might be, but what responsibilities around that tend to surprise people? Anything?
Sure. It's a lot of work. It's that's the biggest thing. You are stepping into the shoes of someone who is no longer available to consult with. You're trying to recreate their financial life and wind up their affairs the best way that you can. There's no benefit to that. It's just a lot of extra work. Oftentimes, clients will come in and they'll want to make sure all of their children are named as executors of their estate. And I iterate to them and sometimes reiterate that this is just additional work for whoever you choose. There's no benefit to it at all. So
right, yeah, and also depending on the complexity of the estate, right? I mean, some matters are probably, the size is probably the bigger it is, potentially the more complicated it's going to be.
Yeah, and the types of assets really make a difference in the complexity of the administration. So if you have a small business that the decedent owned, was a sole proprietor of, or a sole shareholder of, that the business needs to be continued to run or to be wound down, that's a lot of work for someone who is just stepping in to try to wrap things up. It's a lot more than, let's move this bank account over into this account and pay these bills with it, and then everybody signs off and we're good to go. Another example of very difficult areas that administrators and executors run into is savings bonds. Trying to cash in savings bonds that are in the name of the decedent has been proven to be a very difficult process. So there's in certain types of bonds, there's one place that you can send these bonds up to Minnesota to receive an ACH back. And so a lot of times you wouldn't think that people still have savings bonds, but many people still have savings bonds.
Yeah, it's interesting that you mentioned that, because I had come across I went through a move recently, and I had come across in my papers uh, some savings bonds that my mother had gifted to my daughter, who's a full grown adult now. Not a lot of money, but mom gave her some savings bonds, and I just forwarded them on. I'm like, I have no idea where to you know
Right.
where you can cash these things in, but I'm sure she'd figure it out. But yeah, it's interesting that you run into some surprises for sure. And I know you can't name names, but you deal with this stuff every day. I'm curious if you can share a situation where, say, a family was caught off guard by how probate played out, and and what factors made that experience, maybe easier, or I bet you even more difficult. Who knows?
Well, it's always it's I shouldn't say always. It's sometimes a surprise to people when there is an individual who is left out of a will or
Mm.
specifically excluded from a will, and that can certainly cause struggles and an emotional response from both sides. And usually there's a valid reason in the mind of the decedent why that they left that person out, or specifically excluded them. So that's one area that certainly causes some troubles. Another would be a disproportionate share of the assets being distributed to the kids, as an example. So I run into this with my farm families, where certain kids are farm kids and certain kids are the city kids, and the city kids don't really want to be on the farm. They don't farm, and when mom and dad pass, the farm kids end up getting the farm because that's their livelihood. And in certain areas, that farmland is very, very valuable and maybe the most valuable asset in the estate. So then the city kids sometimes get a lesser division, if you will, of a lesser proportion of the estate of mom and dad, and that can cause family conflict, family strife.
Yeah. No, that's we've seen that movie. uh, um, just in the couple of minutes we have left here, I'm wondering if for people out there listening who want to make things easier on their families, saying you just mentioned a situation where you know not knowing why something happened would be could cause a problem later. What types of planning decisions tend to reduce stress and complications during probate?
Being as clear as possible in the writing, in the will itself, certainly is a factor. And then speaking with the your children, speaking with the heirs and legatees of the estate while you're living, and making it clear that, hey, this is why I'm doing this in this manner. And I've even had clients who bring their family in so that I can explain the circumstances, or explain the manner in which the assets would be distributed,
Got
and
it.
so there's no question about that later on.
Frank, great to talk to you. We're out of time, but I know we'll talk again in the near future. Thanks for sharing your knowledge.
Thank you, Sean. I appreciate it.
That's it for today's episode of Practical Clear Guidance on Business Law, Probate, and Estate Planning with Meents Law. If you'd like to learn more about probate or estate planning in Illinois, visit mentslaw.com. That's MEENTS law.com to learn more about Frank Meents and his team. Thanks for listening. Don't forget to like, subscribe, leave a review, or hey, share a link with someone who you think would benefit from this kind of information. I'm Sean O'Connor. Have a good day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.